Friends, the subject of today is very topical, and as was pointed out, it has become more important pursuant to the recent decision rendered by the Supreme Court, which is unprecedented, unparalleled in the sense the use of Article 142 of the Constitution of India to rescue or validate the 90,000 notices that were issued beyond 31st March 21 and up to 30th June 21. In my living memory, the only instance that I have seen of Article 142 being invoked in a tax matter is one of the matters that I had represented in the Supreme Court. This was Greenworld Corporation, where the Supreme Court, while quashing the proceedings under Section 263, had invoked Article 142 to direct an assessment to be made for that very year for which the notice under 263 and the order under 263 was quashed. Other than that, one has rarely not seen use of Article 142 in tax jurisprudence. So this is probably the first time I would say that the article has been used as a way of validating the 90,000 notices, which the court also felt could not be saved since they were contrary to law, since they were on account of bona fide errors committed by the tax department in issuing the notice invoking the provisions of the old law as it stood before 31st March 2021. Now, friends, having said that, while we get into this subject, I thought we will have some history of Section 147 and the scope of reassessment before 2021, and then we will deal with the amendments made from 1421, and thereafter we'll get into this question of what the Supreme Court has decided and what's the way forward thereafter. So just very briefly, I think everyone is well aware of the procedure of Section 147 and the law relating to reassessment prior to 1421. So I will not spend much time on it. I will just point out that under the old law, what was critical was the reasons to be recorded by the assessing officer. And the courts have time immemorial held that the reasons recorded must have a live nexus to the material or information in the possession of the assessing officer. So there must be nexus with the reason to believe that income has escaped assessment with information or material in the possession of the tax department. And initially, the courts were striking down the notices under Section 148 if such link or nexus was found to be missing. So this is some judgments that are there on the concept of reason to believe. This is Narayana versus the judgment in 63 ITR, and I don't need to multiply these authorities. So basically, we can come back to the first slide. I'll tell you when to change. So reason to believe was an important ingredient. And then the question of sanction under Section 151 by the superior authority, and the authorities are divided depending upon the period within which the notice is to be issued. So a sanction has to be by the competent authority who is described under Section 151. And the sanction must reflect application of mind. In fact, courts have also struck down the initiation of proceedings under Section 147, 148, where the commissioner or the joint commissioner mechanically approved the initiation of proceeding without application of mind. So that's another plank on which challenges were mounted to notices issued under Section 148 for initiation of proceedings. The next slide, please. So the time limit, I'm not going into detail in the time limit. The time limit for issuance of notice broadly was 6 years from the end of the relevant assessment year, and where the assessee had been previously assessed under Section 143, and there was no failure on the part of the assessee to disclose fully and truly all material facts necessary for assessment, then in terms of the proviso to Section 147, such a reassessment could not be sustained beyond a period of 4 years from the end of the relevant assessment year. So clearly, while 6 years was the period for initiation of reassessment proceedings, in certain cases, any proceedings initiated beyond 4 years were found to be barred by limitation and therefore were struck down by the courts. The time limit was extended to 16 years in case of foreign assets. So the Supreme Court had considered the Delhi High Court judgment, which had held in the case of Brahmdatt, that this extended limit of 16 years cannot apply with respect to those years for which limitation of 6 years had already expired before the amendment. So the amendment came in 2012. So the Delhi High Court in the case of Brahmdatt held that if proceedings under the old law could not have been initiated as on that date or on the date of in which the amendment came into effect, then in that situation the 16-year time limit will not apply. For friends closer to Mumbai and Pune, you have seen two divergent decisions from the Mumbai bench of the tribunal, and in the case of the husband and wife. So while in the case of the husband, the Mumbai bench has held that the Delhi High Court did not consider the explanation added to section 147 while coming to the conclusion that the 16-year time limit was not available. A discordant note has been struck by another bench, which has taken the view in the case of the wife that the 16-year extended period was not available in the facts of that case. So this is a good reason for the husband and wife to actually get into a dispute and get into controversy between themselves, the two being treated differently by two different benches of the tribunal. So the dust will still settle down on this issue. Then the process that was there under the old regime was, once you receive a notice, then in that situation you need to file a return, ask for the reasons from the assessing officer, and the assessing officer was duty bound to supply the reasons. Thereafter, detailed objections were to be filed, objecting to the initiation of reassessment proceedings if the assessee felt that the proceedings were without jurisdiction, which the assessing officer was duty bound to dispose of by a speaking order. This was the law laid down by the Supreme Court in the case of GK and Drive Shaft in 259 ITR 19. And that law, in a way, diluted the earlier decision of the Supreme Court in Calcutta Company Limited, where the Supreme Court had held that the moment the assessee received a notice under section 148, the assessee could invoke the writ jurisdiction of the court. So GK and Drive Shaft made a departure in the sense that the process needs to be followed. You cannot straight away challenge the notice in a writ petition. You need to first file a return, ask for the reasons, file your detailed objections. Only after the objections are disposed can you then invoke the extraordinary jurisdiction of the court under Article 226 of the Constitution. So this is the law that has been spelled out in these slides, slide 4 and 5. Now this, as I said, I have almost crystallized the issues that arose prior to 1/4/21. So reason to believe I have spoken about that reassessment proceedings cannot be invoked in order to carry out fishing and roving inquiries. Investigation should precede initiation of reassessment proceedings. So this, the courts have come down on the tax department, where the tax department said that there may be escapement of income, or this needs to be inquired into, or this needs to be verified. So the court said that the assessing officer, when he forms reason to believe, although he need not come to a conclusive finding, but there must be a prima facie finding recorded by the assessing officer that income of the assessee has escaped assessment. And that finding must have nexus to the material on record. So you cannot initiate reassessment proceedings in order to carry out further fishing and roving inquiries. That's the crux of these judgments in Chugamal, Rajpal and Batra Bhatta Company. Next slide. Then there were inbuilt checks with regard to exercise of jurisdiction under section 147. One was that on a mere change of opinion, on review or reappraisal of the existing material and facts, it was not open to the assessing officer on his ipsi dixi to seek to take a different view in the matter in the guise of reassessment. So that was the decision of the full bench of the Delhi High Court in Kelvinator, which was affirmed by the Supreme Court in this 320 ITR 561, where the Supreme Court noticed that when the section was first introduced in the finance bill, the word reason to believe was not there. And thereafter, the law was amended to kind of provide this inbuilt check against the wanton exercise of jurisdiction by the assessing officer. And therefore, the Supreme Court said that if the assessing officer had framed the original assessment after due application of mind, then in that situation, on a mere change of opinion, reassessment was not warranted and could not be sustained. This question, whether in the facts of a case there was change of opinion, has also led to substantial debate and matters flocking to the courts. So given the facts of a case, the court considered the question whether there was a change of opinion. Just as a deviation, in some cases, the court also said that even if the assessing officer raised a query, there was a response given, but he may not have dealt with or may not have applied his mind before accepting the assessment, accepting the response made, and not making an addition. So I'm not going into that for a moment, but these are controversies that arise. I've already spoken about the sanction under section 151, that there must be due application of mind. Next. Then there have been cases which talked of that the reasons to believe or the sanction was not provided to the assessing or to the assessee, despite the assessing making a request in that behalf. So the courts have said that if the reasons are not supplied, then in that situation, the reassessment cannot be sustained. It is incumbent on the assessing officer to make the reasons to believe or reasons recorded to the assessee so that the assessee can file the objections to the initiation of proceedings. And this Jeans Net is relevant only for the point that it reiterates the proposition laid down by the Constitution Bench in Calcutta Company Limited, that a writ remedy is available to challenge the initiation of proceedings under section 148. This judgment of Jeans Net disposed of a batch of almost 200 odd matters, largely coming, Jeans Net was from the Karnataka High Court, but largely coming from the Madras High Court, where the Madras High Court had held that since there is an alternate remedy available, the assessee cannot come to the court under Article 226 of the Constitution. So this reaffirms the principle that initiation of proceedings under section 148, where the process as laid down in GK and drive shaft is adopted and followed by the assessee can certainly invoke Article 226 of the Constitution and file a writ petition before the High Court seeking to quash the initiation of such proceedings. Next slide, please. So this was the law as it stood up to 31st March 2021, and there are still disputes pending in the courts on this score. Now, the reassessment scheme that was altered with effect from 1/4/2021, the intent was very laudable in order to cut down on litigation relating to reassessment. And as you are all aware, there will be substantial matters pending in the courts on challenge to reassessment, either by way of writ petitions or through the appeal process under section 260A of the Income Tax Act. So in order to impart finality to assessments, in order that the finality cannot be brushed aside lightly by the assessing officer seeking to invoke proceedings under section 148, this scheme was introduced, and we'll just come to the salient features of this scheme. One second, let's come back to the first one. So basically, this scheme overhauls and substitutes the earlier provisions of the chapter dealing with reassessments, sections 147, 148, 149, 151, and we'll come to this in some more detail. It also does away with the provisions under section 153A and 153C relating to search assessments, where the search is initiated after 1/4/2021. They will also be subject to the reassessment procedure under the amended provisions and the revamped structure. So this has come into effect from 1/4/21. Next slide. So now the assessing officer can invoke reassessment jurisdiction when there is information with the EO which suggests that income chargeable to tax has escaped assessment. Now, stopping here, there are several aspects that arise, and there are several issues for interpretation which will eventually land up in the courts, where one is information with the EO, although this has been defined, which I'll just come to in a moment. Information, what is the basis to say that the information is available with the assessing officer? And the second is suggests that income chargeable to tax has escaped assessment. Now, this suggestion, what is again the connotation of the expression suggests? Does it imply that it must lead to a prima facie belief that income chargeable to tax has escaped assessment? It cannot be a wild suggestion. Clearly, I would think that it cannot be a wild suggestion without any cogent backing of the provisions of law to suggest that income chargeable to tax has escaped assessment. So these are issues that will come up before the courts in the years ahead, when these provisions are challenged. For the time being, information has been legislatively defined in explanation 1 to section 148, and it says any information in accordance with risk management strategy of the board, any information flagged in accordance with risk management strategy of the board, any audit objection that assessment has not been made in accordance with the provision of the Act, any information received under DTAA, any information made available to the assessing officer under the scheme notified under section 135A, any information which requires action in consequence of the order of the tribunal or of a court. Now, I have seen of late that under this new procedure that has been invoked, invariably the assessing officer says that he has reason to believe that income has escaped assessment in accordance with information made available as per the risk management strategy of the board. Frankly, one is really not aware of this risk management strategy. It is not available in the public domain. I think that's their internal document. And basis that, the assessing officer may be passed on information, and the assessing officer therefore steps into the domain of section 148 to issue a notice under that section to reassess and reopen the concluded proceedings. Now, this information we have found in several cases to be extremely vague. That may only be a flash that certain transactions are carried out by the assessee, but that by itself cannot lead to a conclusion, or that cannot suggest that income chargeable to tax has escaped assessment unless thereafter the assessing officer goes into further detail of the matter. Again, this question of information and the scope thereof will be subject matter of debate, dispute in the courts in the years to come. Next slide. Now, this is the new procedure that the assessing officer first issues a show cause notice under section 148 capital A. That under that show cause notice, the assessing officer would put the assessee to notice saying that I have information that income of the assessee has escaped assessment, and he is required to make that information available to the assessee, confront the assessee with that information. And thereafter, it says 148A says that he may conduct inquiry if required with the prior approval of the specified authority with respect to the information which suggests that income of the assessee has escaped assessment. So this is a stage that he needs to do prior to issuing a show cause notice to the assessee. Now, thereafter, the show cause notice is issued and the assessee is provided an opportunity to rebut whatever information is available with the assessing officer, give his response. That is in terms of 148AB, and the time limit that is specified for the assessing officer to make available to the assessee is a minimum period of 7 days, but not exceeding 30 days from the date on which notice is issued, or such time as may be extended on the basis of an application. So he would be giving a show cause notice saying that why should your assessment not be reopened? Why should a notice under section 148 not be issued to you? So thereafter, once this notice is issued, the assessee would furnish a reply within the stipulated time. That is the reply under section 148 capital A bracket small c. Once the assessing officer receives the reply of the assessee, he has to deal with the objections raised by the assessee. He has to pass an order under 148AD dealing with the objections raised by the assessee, dealing with the material on record, and determine whether this is a fit case for issuance of notice under section 148, again with the approval of the specified authority, which we come to are specified in section 151. So here 148AD, once the assessing officer passes an order coming to the conclusion that this is a fit case for issue of notice under 148, the notice thereafter would be issued either along with this order or subsequent to passing of this order. So thereafter, the assessee would be required to file the return of income pursuant to the notice under section 148 of the Act. And thereafter, the assessment or reassessment would be concluded by the assessing officer. Now here, basically, if you see, the earlier scheme and the earlier process outlined by the court in GK and Drive Sharp has been legislatively incorporated in this new chapter. The intent is that the intent was, and we can possibly use as in the past tense, going by the experience that one is seeing in the courts, that the intent was that the assessing officer applies mind, filters out cases where, according to him, it may not be a fit case to continue with the proceedings once he is satisfied with the response furnished by the assessee. But invariably, going by, again, the experience that we've seen with respect to matters coming to the courts, the assessing officers hardly look at the response that is furnished and in a rush proceed to issue the notice under 148 after rejecting the objection of the assessee in the order that is passed under 148 AD. There have been challenges in the court with respect to the orders passed and the issue of notice under section 148. Now, in the previous slide, one had mentioned that in case of search and seizure, ipso facto, this is regarded as a case where information is available to the assessing officer. So in that situation, the entire scheme of passing an order under 148 AD and all is not required. Those will be automatic cases where notice can be issued under section 148. Now, the amended provisions which are made applicable from 1421 have curtailed the time limit to 3 years from the end of the relevant assessment year for initiation of proceedings under section 147. The first question that arises is whether this reduced time limit will apply with respect to pending matters or whether it will apply to assessment years prior to 1/4/2021. The normal rule is that matters relating to assessment or reassessment are a matter of procedure. Limitation also with respect to the assessment is therefore procedural, and if the limitation is curtailed by a subsequent legislation, that curtailed limitation will apply with respect to the pending proceedings. This was the law laid down by the Supreme Court in K.M. Sharma's case, which was followed by the Delhi High Court when earlier the time limit, if you recall, for reopening was 10 years, which was reduced to 6 years. The Delhi High Court in the case of C.B. Richard Alice, following that principle, held that only the curtailed time limit would apply with respect to pending matters. So the 3 years will be the sacrosanct time limit for matters for which reassessment proceedings have not been initiated as on 1/4/2021. And then the time limit of 10 years is provided, and I think this is very material. Whether the 10 years will apply in any and every case is extremely important. It says where 10 years, if 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books of accounts or other documents or evidence which reveal that income chargeable to tax represented in the form of an asset, expenditure in respect of a transaction or in relation to any event or occasion, or an entry or entries in the books of accounts which has escaped assessment amounts to or is likely to amount to 50 lakh rupees or more. I think Ketan Bhai was referring to the enlargement of this scope of 10 years to include expenditure in respect of a transaction or any entry or entries in the books of accounts. So my view is that this 10-year limit cannot ipso facto apply in any and every case. There must be in the possession of the assessing officer books of accounts or other documents or evidence. Now, whether these books of accounts refer to your regular books of accounts, to my mind, the answer is no. These are books other than your regular books of accounts for reappraisal of or review of your existing record and your existing books of accounts, your regular books of accounts, which form part of your return on the basis of which your return is filed. That, according to me, cannot be read as books of accounts on the basis of which this extended time limits of 10 lakhs can apply, 10 years can apply, notwithstanding that the information may be in the form of an asset, expenditure, or entry in the books of accounts. That would amount to reappraisal of existing material. So therefore, the first issue that will arise is, can this extended period of 10 years apply merely because the income that the assessing officer feels has escaped assessment is represented in the form of an asset, which is duly recorded in your books of accounts, or an expenditure again recorded in your books of accounts. So here, according to me, this cannot refer to your regular books of accounts. This may refer to a duplicate set of books of accounts or any material that comes to the possession of the assessing officer, whether pursuant to a search, whether on the basis of information that the tax department may have got, basis search carried out at the place, at somebody else's place, and so on. That information that is passed on to the assessing officer. So clearly, it is my personal view, but this will need to be tested in the courts. So this limit of 50 lakhs and the fact that the extended time limit of 10 years will apply is again an open question, which the courts will have to decide as and when matters get to the court. Next slide. The other important principle in this case is that if the time limit ordinarily had expired up to 31st March 21, then this extended period of 10 years cannot apply. So if the normal time limit of 6 years had expired on 31st March 2021, then in that view, the assessing officer cannot fall back on this amended provision to say, I have now time up to 10 years to reopen the assessment. This, to my mind, in a way recognizes the principle laid down in the case of Brahmdatt, laid down by the Supreme Court in K.M. Sharma, and also followed in C.V. Richard Ellis. So if the assessment proceedings had attained finality and could not be reopened up to 31st March 2021 by a flux of time, thereafter the assessing officer cannot say that I will use this additional 4 years to reopen the proceedings, even though they could not have been legitimately reopened up to 31st March 2021. Next slide, please. So these are the time limits that are provided in section 148, where it says 148A, where for the purpose of issue of notice under 148, the time that is allowed by the assessing officer to the assessee to respond to notice under to show cause notice under section 148B, and the period during which proceedings are stayed by any court, that will need to be excluded. And the further deeming provision is, if after excluding the aforesaid period, time available for passing order under 148 ED is less than 7 days, the remaining time shall be extended to 7 days. So we will see how this will become material when we interpret the Supreme Court judgment in Ashish Agarwal's case. The specified authority under section 151 for issuing of sanction and giving approval under various aspects of 148A, they have been specified as the principal CIT or principal DIT, CIT or DIT, where 3 years or less have elapsed from the relevant assessment year, and where more than 3 years, then it is the principal chief commissioner or principal director general, and so on. Then further safeguard is that in the case where reassessment is initiated on the basis of deemed information, that is search, requisition and survey cases, the reassessment order and not the notice, the reassessment order cannot be passed by an AO below the rank of joint commissioner, except with prior approval of the additional commissioner, additional DIT or JCIT. This is section 148B. I think we have a comparative analysis of the scheme of reassessment pre and post 1/4/2021. I'll straight away ask my colleague to come to the tabulation. This is the tabulation of the changes made in the reassessment regime pre and post 1/4/2021. I'll skip this because I think everyone is possibly aware of this issue. We can move on with this. Now, this is now the build-up to the Supreme Court decision. If you recall, we were all gripped by the pandemic, and the government was from time to time extending the time limits for passing of order, issue of notices, even helping the assessees to file belated appeals and so on, as a result of disruption caused by COVID-19. Now, although the Finance Act 2021 provided that the new reassessment scheme shall be effective from 1/4/21, including the reduced time limit, the TOLA extended the time limit for issue of notices under 148 up to 30th June 2021. Now the question was that a notice issued up to 30th June 2021 for years prior to 1/4/2021 was valid. And the controversy was, if you apply the reduced time limit of 3 years that was introduced from 1/4/2021, the proceedings were clearly barred. If you took into account the original time limit as extended by TOLA, there was time available up to 30th June 2021. Now, this conflict landed before different high courts, and almost all high courts unanimously, except for a solitary dissenting view given by the Chhattisgarh High Court, the Allahabad High Court, the Delhi High Court, the Bombay High Court, the Rajasthan High Court, the Karnataka High Court, the Gujarat High Court, all took the view that notices issued after 1/4/2021 had to necessarily conform to the new assessment regime introduced from 1/4/2021, and therefore this extended time limit made available in terms of TOLA could not be invoked by the revenue to sustain and validate the notice issued after 31st March 2021. This was one of the leading judgments was the decision of the Delhi High Court in Manmohan Kohli, although there were decisions from the Allahabad and Rajasthan High Courts which had come prior to the decision being rendered in the case of Manmohan Kohli. Now, this Allahabad High Court judgment in the case of Ashish Agarwal was made the lead case before the Supreme Court. The government was still in the process of filing appeals against the orders of appeals against the orders in the case of several assessees who came from different high courts. Now, the Supreme Court thereafter dealt with this batch of matters to the extent they were filed, and in a path-breaking judgment, which you would have seen extensively reported in the press, validated the notices by invoking their powers under Article 142 of the Constitution. I can do no better than to read the concluding observations of the Supreme Court. So the Supreme Court from para 5 onwards analyzed the scheme of the Act pre and post 1/4/2021. And then para 7 onwards is the finding of the Supreme Court. I'll just seek to read this. Para 7 reads, thus the new provision substituted by the Finance Act 2021 being remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interests of the assessee as well as the same being in public interest, the respective high courts have rightly held that the benefit of new provision shall be made available even in respect of proceedings relating to past assessment years, provided Section 148 notice has been issued on or after 1st April 2021. We are in complete agreement with the view taken by the various high courts in holding so. So to this extent, there is affirmation of the decision given by the high courts that notices issued post 1/4/2021 pertaining to assessment years prior to assessment year 21-22 are to conform and are to be in sync with the new provisions of Section 148 introduced with effect from 1/4/2021. Thereafter, now this is the path where the Supreme Court deviates from what has been said by the High Court, and this is para 8 onwards. However, at the same time, the judgments of the several High Courts would result in no reassessment proceedings at all, even if the same are permissible under the Finance Act 2021 and as per substituted sections 147 to 151 of the Act. The revenue cannot be made remediless, and the object and purpose of reassessment proceedings cannot be frustrated. It is true that due to a bona fide mistake and in view of subsequent extension of time by various notifications, the revenue issued the impugned notices under Section 148 after the amendment was enforced with effect from 1/4/2021 under the unamended Section 148. In our view, the same ought not to have been issued under the unamended Act and ought to have been issued under the substituted provisions of Section 147 to 151 of the IT Act as per the Finance Act 2021. There appears to be genuine non-application of the amendments, as the officers of the revenue may have been under a bona fide belief that the amendments may not yet have been enforced. Therefore, we are of the opinion that some leeway must be shown in that regard, which the High Courts could have done so. Therefore, instead of quashing and setting aside the reassessment notices issued under the unamended provision of IT Act, The High Courts ought to have passed an order construing the notices issued under unamended provision of the IT Act as those deemed to have been issued under Section 148A of the IT Act as per the new provision Section 148A, and the revenue ought to have been permitted to proceed further with the reassessment proceedings as per the substituted provisions of Section 147 to 151 of the Act as per the Finance Act 2021, subject to compliance of all the procedural requirements and the defenses which may be available to the assessee under the substituted provisions of sections 147 to 151 of the IT Act, which may be available under the Finance Act 2021 and in law. Therefore, we propose to modify the judgments and orders passed by the respective high courts as under. Now here, basically, if you see, the first part is that the judgments of the High Court would result in no reassessment proceeding at all, even if the same are permissible under the Finance Act 2021 and as per substituted sections 147 to 151 of the IT Act. We stop here. The question that will arise, and I am sure many of you would be raising that question, is post this Supreme Court judgment, can the proceedings which were otherwise barred on 31st March 2021, if you take into account the curtailed time limit of 3 years, whether those are saved by the Supreme Court decision? So here, as per the Honorable Court, in fact, the court has not dealt with this question, that if TOLA had extended the time limit from up to 30th June 2021, whether those notices will be saved if they have been issued post 1/4/2021 and up to 30th June 2021. So that, to my mind, will be an open question. But at the same time, the court has added a caveat saying all defenses that are available under the substituted provisions of sections 147 to 151 and which may be available under the Finance Act and in law would be available to the assessee. So these are several questions that arise from the judgment of the Supreme Court. I gave just one instance. We'll deal with more as we come along. So thereafter, the Supreme Court says, therefore, we propose to modify the judgments and orders passed by the respective high courts as under. The respective impugned section 148 notices issued to the respective assessees shall be deemed to have been issued under section 148A of the Act as substituted by the Finance Act 2021 and treated to be show cause notices in terms of section 148AB. The respective officers shall within 30 days from today provide to the assessees the information and material relied upon by the revenue so that the assessees can reply to the notices within 2 weeks thereafter. So by a deeming fiction, by invocation of Article 142, the Supreme Court has held that these notices that have been issued will be deemed to be notices issued under section 148A. They will be treated as show cause notices under 148AB, and the assessing officer, even though he did not supply that information, will be required to submit to the assessee the information and material relied upon by the assessees within 30 days from the date of the Supreme Court order. And the assessees have 2 weeks thereafter to furnish a response. Then it further goes on to state the requirement of conducting any inquiry with the prior approval of the specified authority under section 148AA be dispensed with as a one-time measure vis-a-vis those notices which have been issued under section 148 of the unamended Act from 1/4/2021 till date, including those which have been quashed by the high courts. So no inquiry is required, but at the same time, the material with the assessing officer should be supplied to the assessee. The assessing officer shall thereafter pass an order in terms of section 148AD after following the due procedure as required under section 148AB in respect of each of the concerned assessee. All the defenses which may be available to the assessee under section 149 or which may be available under the Finance Act 2021 and in law, and whatever rights are available to the assessing officer under the Finance Act 2021 are kept open and or shall continue to be available. The present order shall substitute, modify respective judgments and orders passed by the respective high courts, quashing the similar notices issued under unamended section 148, irrespective of whether they have been assailed before this court or not. Then, para 9 states, I think, for those assessees and those counsels who appeared, I think there is disagreement. There is a broad consensus on the aforesaid aspects amongst the learned ASG appearing on behalf of the revenue and the learned senior advocates, learned counsel appearing on behalf of the respective assessees. We are also of the opinion that if the aforesaid order is passed, it will strike a balance between the rights of the revenue as well as the respective assessees. As because of a bona fide belief of the officers of the revenue in issuing approximately 90,000 such notices, the revenue may not suffer, as ultimately it is the public exchequer which would suffer. Therefore, we have proposed to pass the present order with a view avoiding filing of further appeals before this court and burden this court with approximately 9,000 appeals against similar judgments and orders passed by the various high courts, the particulars of some of which are referred to here and above. We have also proposed to pass the aforesaid order in exercise of our powers under Article 142 of the Constitution by holding that the present order shall govern not only the impugned judgments and orders passed by the High Court of Judicature at Allahabad, but shall also be made applicable in respect of the similar judgments and orders passed by various high courts across the country, and therefore the present order shall be applicable to Pan India. In view of the above and for the reasons stated above, present appeals are allowed in part. The impugned common judgments and orders passed by the High Court of Judicature at Allahabad and other allied tax appeals are hereby modified and substituted as under, which is what I read. The concluding part in para 10 gives again the process that needs to be followed post the rendition of judgment by the Honorable Supreme Court. Now, as I mentioned, this judgment has opened a Pandora's box, has left many questions unanswered, and again, as we actually get down to practice, these questions will arise on a day-to-day basis, and they will again be flocking the courts. Importantly, I don't know how many of you are aware, yesterday this letter was circulated, written by the Income Tax Gazetted Officers Association to the chairperson CBDT, referring to this judgment, and I would want to read. Even the department is clueless of how to proceed in the matter. The department says, our interpretation of the judgment is given as under, all the notices issued under 148 under the pre-amended provision are to be treated as show cause notice under 148B. A has to communicate the information, assessee has to reply, AO with the approval of the specified authorities to pass order. Then he says, however, this is what the Gazetted Officers Association is writing. However, we are not certain about the following. A, who is going to handle such cases? The FAOs, the faceless assessment officer, or the JO, the jurisdictional assessing officer, especially in view of notification dated so and so. Then can the AO issue notices in respect of cases of assessment years 15, 16, 16, 17 and 17, 18 that have escaped income below 50 lakhs, as those will be beyond the 3-year limit as on 1/4/2021. Then item C, can the AO at all issue notices in respect of cases of assessment year 13, 14 and 14, 15 which are beyond the 6-year time limit as on 1/4/21. The notices were initially issued as assessment year 14, 15 was within 6 years and 13, 14 had the facility of extension of time allowed due to COVID pandemic. Further, what happens if the escapement of income for these 2 years is below 50 lakhs? Then during the period from 1/4/2021 to 30th June, notices were issued based on information from 4 sources, from other AOs, from other agencies, that is from the third, from investigation wing and inside portal. Other than the information received from inside portal, no other source qualify for criterion of flagged in accordance with the risk management strategy. Will the AO proceed in these cases where information is not flagged in accordance with risk management strategy? How will the information reason be sent to the assessee, through email or ITBA portal? If through ITBA portal, then how to issue the same when 148 notices have already been issued and nothing is pending in the work list? If the communications are to be made through ITBA portal, by what time will the functionality be put in place? Then they deal with basically 5 types of cases: assessees who filed writ petition, assessee who did not file any petition before any high court, assessee who did not file any petition themselves, but after the verdicts of different high court challenge the validity of notice before the JO, assessee who have not challenged the issue of notice at all, assessees who have not challenged the issue of notice and filed ITR in response to the notice. Now the question whether the AO needs to send information and consequently pass order under 148AD followed by issue of notice under 148 in fit cases to all the assessees as above, or to only certain segments of the assessees. So as you can see, even the department is at a loss on how to implement the directions passed by the Honorable High Court, Supreme Court in this judgment. And I'm sure all of you will have substantial questions. I do not claim to have any clear answers to questions that you and queries that you will seek to raise, but I will try my best to answer it to the best of my ability. Ketan Bhai and Amya, I think I will hand it back to you. I would like this to be more interactive than my continuing with this monologue.
Sure. Thank you.
If that is all right with you, I think we can do that.
Sure. Thank you, Ajay ji. That leaves a lot of time for question and answers, and we have several questions in the Q&A box. And till Sachin gathers the first set of questions, Ajay ji, I think the letter addressed by the association itself raises some of the pertinent points, and those are also the questions on the minds of the people or the audience over here. Any one or two questions raised in that letter itself which you would like to take up first, and then Sachin can get into some of the other questions.
I think the larger question that is coming to mind is whether the reassessment for assessment year 13-14 and 14-15. Right now, 13-14 clearly 6 years were over on 31st March 2020. Now, whether they can be saved even after this Supreme Court judgment, because from 1/4/21 the time limit of 3 years were to apply. Now, the Supreme Court has left that controversy open, whether the time should be treated as extended up to 30th June 21 basis the TOLA. Now, that was a large controversy which the High Courts unequivocally and unambiguously held that time was not extended for issue of notice. And if the notice was barred by limitation as on 31st March 2021, that could not have been saved by the extension provided in TOLA. Of course, subject to the dissenting view taken by the Chhattisgarh High Court. So that aspect is still open. It has not been answered by the Supreme Court. When the Supreme Court says that we are in agreement with the High Courts, that the amended provisions of section 148 or the amended chapter needs to apply with respect to notices issued after 1/4/2021. So 13-14, 14-15, as the department's association has also raised, whether they are competent to at all issue notices for those 2 years. Again, further segregation that if the time limit is to be available, whether the escaped income should be 50 lakhs or more, in order that those notices can be saved. Now, if you see the Supreme Court decision, there are no clear answers. But what the Supreme Court has said that the defenses under section 149 are available to the assessee. Now, if the assessee contends that these proceedings for 13-14, 14-15, or even years which were otherwise barred, if we apply the 3-year time limit, and basis the application of law laid down in KM Sharma and other cases, that the reduced time limit should apply. Now, if that be the case, there are many years where the notices should be struck down. Then the further question will be that whether this extended time period of 10 years, which I flagged in my opening remarks, whether that should apply ipso facto automatically, even if the assessing officer does not have in a possession books of accounts or information, books of accounts and information suggesting that income has escaped assessment and which is represented in the form of asset entry in books of accounts or any transaction. So that again will become material. What do you mean by the assessing officer has in his possession books of accounts or other documents? He can't possibly be retaining your regular books of accounts. Those regular books of accounts are not impounded. He may have your balance sheet, profit and loss account filed along with the return, or he may have information that you filed in the course of assessment. But that cannot amount to saying that he has in his possession books of accounts. So these are questions, again, frankly, I have no answers. It will lead to another extensive round of litigation when people tend to get back to courts, challenging the proceedings that are initiated. Once again, the proceedings already stand initiated. One, the department seeks to take off from what the Supreme Court has directed by treating the notice already issued as a notice under section 148 capital AB, making available to the assessee information in their possession. And as the association has flagged, can you say that this is information flagged as per the risk management strategy? None of us have a clue what the internal risk management strategy is, but according to the association, can you say that this is basis the risk management strategy that this information is flagged, and does it satisfy the criterion for assuming jurisdiction under the amended provision? So I would think that that may not be open, because once the Supreme Court deems this to be a notice under 148 capital A, then it is assumed that the initiation is based on material information that is already available with the assessing officer. So all these are open questions. No clear answers. No clear answers.
Right, right. Thank you, Ajay ji. I'm sure some more guidance will come through in the rest of the Q&A as well from you as an advocate. What's your view if you were to wear a professional and advisor's hat? But
Right.
Sachin,
Sure.
request if you could pose a few set of questions to
Sure.
Ajay ji.
So Ajay ji, I think a couple of questions were relating to the extension of time limit, but which you have already answered. And few questions I'm just trying to paraphrase the set of questions here.
Right.
I think more confusion lies for AY 14-15 and 15-16.
Right.
These are the 2 years where possibly I think your guidance is required more. And one more aspect for those particular 2 assessment years. What if you have received the notice from the department and you have already completed the assessment for AY 15-16? You might be in appeal or you may not be in appeal. But
No, again, no, you need to clarify. When you say 15-16 assessment, or you're talking of reassessment, original assessment or reassessment?
So AY 15-16 reassessment notice was received by you before 30th of June 2021. You have answered the questions and the assessment is already complete. Now, whether that assessment gets reopened because of this, because there are certain procedures needs to be followed for AY 15-16?
No, from what I assume, basis what you have mentioned as the facts of the case, I assume that the assessee did not challenge the reopening in a court of law, right?
Yes. Yes.
The assessee participated in the assessment and the reassessment stands concluded.
Correct.
Now, there is no bar in the assessee seeking to challenge the jurisdiction to frame a reassessment under this amended provision before the commissioner appeals for the first time. No, this will you will not go back to a stage where this will be treated as a notice issued under 148A. But the CIT appeal will assume that the notice that was issued was a notice under 148A basis the declaration of law by the Supreme Court, and then determine whether the reassessment is valid or not valid.
Okay. Okay. Fair point. Fair point. And similar, one more question on AY 15-16 itself. Now that Supreme Court has said that this all 148 notices will be treated as a 148A show cause notices. So what happens to now the time limit will start now as far as the 148A show cause notices will assessee will get the information, then they will put their submission, and then 148D order will be passed. So 149 time limit is 3 years. So how can it once that order is passed on 148D, till what is the year where he can go back now, or the time limit exclusion which is provided in 149 will kick in and the benefit will still be available to the assessing officer?
See, basically, there are clearly 2 views around the table on this issue. Assessment year 15-16 under the old law could have been reopened up to 31st March 22. Right? So time was available up to 31st March 22. 1421, the time limit got reduced to 3 years. So if notice could not have been issued as on 1421, then clearly those proceedings that were not initiated for assessment year 15-16 could not have been initiated post 31st March 21 in view of the introduction of law curtaining the time limit to 3 years. So therefore, notwithstanding that the Supreme Court has deemed this to be a notice under 148D, as 148B, as the Supreme Court itself has said that defenses under 149 are available to the assessee. So the assessee would contend that the 3-year time limit will apply basis the amendment in law, and this being a procedural amendment relating to limitation, that has to apply to pending proceedings. So post 1421, this notice could not have been issued, and therefore these proceedings are barred by limitation. So that's one approach. So therefore the assessee will need to challenge when it goes to a court of law, saying that the assessing officer cannot continue with these proceedings, notwithstanding what the Supreme Court has directed. And as I said, the Supreme Court has not dealt with this question of extension of time being available in terms of TOLA. The contrary view would be that if the Supreme Court wanted to quash these notices for those years for which time had already expired in view of the reduced time limit of 3 years, then in that situation, the Supreme Court would have said that these notices do not survive. And the direction will apply to notices for other years, which could validly have been issued after 1/4/21. That's the counter view that the department would give. And therefore, according to them, since this is now deemed to be a notice under 148A, the aspects relating to limitation that may only be looked at is whether the order under 148AD is passed within 30 days of his making his objections available and so on. That is what is provided in the new provisions. So that will be the counterpoint of view.
Okay.
So as I said, again, there is no harm in the assessees raising this objection, but which way it will be decided is difficult to hazard a guess.
Okay.
But certainly one must put our foot in the door, not give up this objection.
Okay.
Right. Ajay-ji, a few set of questions around the judgment itself. One is that these were coming out of the writ petition. So is the effect of this judgment restricted only to the cases which were where a writ has been filed, or do they apply to all the cases of reassessment notices, whether a taxpayer has gone into writ or not? Number one. And number two, is there a scope for a review as well for this judgment? The two questions.
I think if you see the judgment, the judgment says that this judgment will apply pan-India, and therefore, even if the assessee may not have gone to the High Court in a challenge, this to my mind will be a declaration of law. You cannot possibly treat those assessees who approach the High Court differently than other assessees who may not have mounted a challenge to the initiation of proceedings. When it says this present order shall be applicable pan-India, and all judgments and orders passed by different high courts on the issue and under which similar notices are issued are set aside and shall be governed by the present order and shall stand modified to the aforesaid extent. So, where I assume that where the assessee has not challenged the jurisdiction of the AO, the assessee has accepted that this is in accordance with law. They can't be on a better footing than those who went to the court.
Right. Okay. Right. And any review petition, any thoughts that you heard?
No. See, basically, if you look at the statistics, I think 99+% of review petitions are dismissed in the chamber itself. There is no requirement of giving a hearing. You thereafter, you request for an open hearing of the review petition. And once the review is dismissed in the chamber, then you file a curative petition. It is seldom and very rare that a review is allowed or the review comes up for open hearing. One instance that one has seen in recent times is this review of the royalty judgment in engineering analysis, where the Chief Justice has directed that will be heard in the court, in open court. There is clearly no date fixed for that matter as well. But I doubt very much that the review will lead anywhere. The review can only lead to clarity, but cannot possibly lead to an upsetting of the judgment.
Right.
And review can only be for apparent mistakes. The scope is extremely limited. At least I don't hold out much hopes on a review.
Right. Appreciate. Sachin, over to you.
Yeah. Ajay bhai, some of the questions are on the technical reassessment points without really referring to this Supreme Court judgment. So one of the question is on whether Section 194 talks about income represented in the form of asset. And so asset on which date? Is it the cost of the asset or is it the fair market value of the asset, and on which date? And additionally, books of accounts is to whose books of account? Is the assess's books of account or somebody else's books of account representing, some income relating to you also? So if these two questions can be answered.
Oh, so you see, if you talk of books of accounts, it will be your books of accounts, but other documents or evidence will be somebody else's books of accounts.
Okay.
So the phrase is wide enough. In his possession, books of accounts or other documents or evidence. And the other question that you raised is asset on what date? So you are seeking to, under the Income Tax Act, you seek to tax the investment made in an undisclosed asset. Now you have to bring it within any of the specific provisions where you talk of Section 69 and so on, that where it comes to the notice of the assessing officer is found to be the owner, or if you have duplicate books of accounts where an asset is recorded. Now in that situation, you will seek to tax the investment in the asset, not the market value of the asset. Unlike the Black Money Act, the Black Money Act specifically provides that you have to take the value as on the last day of the previous year with respect to that undisclosed asset. Income Tax Act brings to tax the income that is represented in the form of investment in the asset. So this will basically be the cost for which you acquired the asset.
Amey, any question you want to ask?
Yeah. So Ajay's, a few questions more on the principle and approach of the Supreme Court over here is that, there's a line of thought that ignorance of law cannot be an excuse, and in a way, Supreme Court appreciating the difficulty over here sort of delivered a verdict. So, and also, as you mentioned the beginning, use of Article 142 in this situation is unprecedented. Any thoughts more at a philosophical level around the approach of this judgment, Ajay?
I think basically, the prejudice that would be caused to the revenue if these notices were quashed is, I think, what was highlighted and pitchforked in the forefront by the revenue in order to gain the sympathy of the court that this bona fide misunderstanding or understanding of the law as a consequence of the law being amended from 1/4/21 and the pandemic taking over is leading to extension of time for issue of the notice. So that overlap that happened in that time in the estimation of the revenue led to this misunderstanding of bona fide error in understanding on the part of the officers when they issued these notices beyond 31st March 2021. And on that basis, the Supreme Court came in to say that, these notices need to be saved if these are bona fide errors of judgment. As you very rightly said, ignorance of law is no excuse. That is, I think, an oft-quoted maxim that is repeated and found in several Supreme Court judgments. And that I think that's a salutary principle. But in this case, as I said, maybe considering the stakes involved, maybe considering the magnitude of the issue and the fact that there was this overlap, this genuine overlap, the Supreme Court has used this article in order to revalidate, revive these notices and save these notices, which would otherwise have been lost once the Supreme Court agreed with the High Courts that the assessing officers ought to have followed the amended law from 1/4/2021. I have seen, as I said, in tax only one earlier instance, and I stand to be corrected. At least I have seen one instance where Article 142 has been used, notwithstanding that the scope of that article is extremely restricted and limited. Increasingly, the court is now using Article 142 in, at least I have seen one or two cases where family disputes have been settled under Article 142. The Supreme Court judge who was appointed as a mediator has recommended to the court to pass an order under Article 142 to settle disputes inter se between members of a family. And the question that was posed to me as a counsel was, would this order be binding on the tax department, even though the order recorded that there will be no tax implications of the settlement? And again, that is an open question, whether the income tax department, who was not a party to that mediation, who was not a party to the inter se dispute, can be said to be bound by what has been directed in that article, in that order using Article 142. Somebody mentioned to me that husband's wife matrimonial dispute was settled through use of Article 142. So it is to do complete justice between the parties that the court invokes this special power, and in very rare cases, in terms of Article 142, that is reserved only to the Supreme Court.
Right. Thank you, Ajay ji. Sachin?
I think it's just a corollary question, Ajay bhai. I think one of the participants is asking is whether this Supreme Court judgment can be referred to a larger bench or a constitutional bench on the ground that this judgment is violative of Article 265.
No, theoretically, yes, but the question will be practically if that is possible or not. If the judgment is doubted as not being in accordance with the Constitution or not being in accordance with the law, then whether another bench would seek to refer it to a larger bench. That will be the question.
Okay.
Maybe a successor bench, seized of the same issue, who doubts the efficacy of this judgment or the validity of this judgment, may propose to refer it to a larger bench.
Okay. One set of questions, Ajay bhai, is being asked that, under the old law, we had a reasons to believe and the tangible material, all those, set of concepts which were deliberated by various court decisions as well.
Right.
And now it has been changed to the information, and the matter or the definition of information itself has undergone a change when it was introduced in Finance Act 2021 and then 2022. So what exactly is, the assessee or the tax practitioners look out here, that whether the reasons to believe concept is completely gone, and this information has to be then strictly as per the information which is as defined under the new section?
See, the information is statutorily defined. What is the nature of the information? And when it says means, I think it is exhaustive. This explanation one defines information, that information with the assessing officer which suggests that income chargeable to tax as escaped assessment means. So it will be illustrative, it will be a code in itself. I don't think there can be anything beyond this which can constitute information. Now the other question will be which suggests that, and what should be the suggestion? Should it be at least some reasonable, tangible basis to come to the conclusion that income has escaped assessment? As I said, the suggestion cannot be a wild suggestion. It must be well thought through. It must be after application of mind. It must lead to that, at least that prima facie belief that income has escaped assessment. So the word suggest may not be equated to reason to believe, but at the same time, it cannot be, wild gossip, rumor. That cannot follow. That will be my view. Again, this will have to be tested in courts.
Right. Ajay ji, if we sort of look at the period of next 30 days, what might possibly pan out? And, I'm sort of again paraphrasing a few sort of questions over here. There have been notices where, let's say, writ has been issued, and, those are one classical set of notices. That's one category. The second category is, let's say, the initial notice itself otherwise defective, and, assessee is under challenge. Can such defect be curated by the department? That's number two. Number three, the third category.
This is not very clear. What did you want to say? Not
Sorry,
very
no,
clear.
I'm just putting forth the 3 or 4 categories of cases which you know, where the impact will have to be assessed separately. One is a straightforward case where assessee went into writ and you know,
Right.
it's challenging. The second category is, let's say the original notice is defective on other grounds other than the TOLA and 148A related proceedings. Does that give a additional window to the department because of the Supreme Court order now to correct those defects if there are any? The third category is, let's say the assessee did not file a writ, it has made the submissions, etc. voluntarily as well. Would the process have to be followed all over again in those cases because of the Supreme Court direction? And fourth, and one participant has pointed out that maybe there is already an reassessment which is also already complete in the last 9 months. I don't know how many people have encountered this, but someone has pointed this out.
I think
So
that question came earlier also, that the reassessment has already been completed. As I said, you challenge it before the Commissioner appeals if it does not conform
right,
to the jurisdictional condition. Now, so far as the first one is concerned, those who filed a writ clearly will be at the stage where the Supreme Court has directed. Now, the second category where the notice suffers from other defects also, those defenses are still available. I don't know what is the nature of defect that you want to point out, but those defenses will be available to the assessee to contend before the assessing officer.
right.
And third one that you mentioned, the fourth one was, of course, where the reassessment was made. The third one was?
Where the taxpayer has already filed the replies and the reassessment is in progress.
I don't think those will be impacted.
Sure.
There the assessing officer is in any case following this process of 148A.
Sure. All right, Sachin, over to you.
Okay, I think most of the questions, Ame, we have tried to paraphrase and put it to Ajay ji. If Ajay ji, I think if you want to proceed with your presentation in this, let us know.
Sorry, come again, sir. No, Sachin,
so most of the questions which have been asked so far. Can you hear me, Ajay ji?
Yes.
Okay, so most of the questions which have been asked in the Q&A box, we have tried to paraphrase it and ask it to you. Would you like to continue with your presentation, remaining presentation, so that then we can still go in the Q&A box and look for if any question is unanswered.
Right. Okay. So I think we'll come back to page 29. We'll just put up the slide, page 29. So I think this is under the new procedure. What shall be the remedy available to the taxpayer under orders passed under section 148D? Now here basically the matters that have come to the court at the moment deal with a situation where adequate opportunity of hearing has not been provided, or the assessing officer has not applied mind to the objections that have been raised by the assessee. So the Delhi High Court has basically set aside such kind of matters back to the assessing officer to either provide opportunity or in order to redecide the objections that have been filed by the assessee. So I have not seen a major challenge on the scope of this new amended provision of what is the nature of information and so on. So that is still an open question that has probably not come up before the courts, whether this answers the description of information which suggests that income has escaped assessment. So as I said, according to me, it cannot be rumor, gossip, or hearsay. It must be based on some tangible material. And the further question of the 10-year time limit, whether it should apply with respect to regular books of accounts, if there is an entry in the regular books of accounts, or if there is an asset reflected in regular books of accounts, to my mind, that is not feasible, or that is not possible. But again, something that the courts will have to opine upon. So far as the 3-year time limit is concerned, clearly there don't seem to be too many fetters on the exercise of jurisdiction by the assessing officer within the 3-year period. One will really have to see whether the concept of change of opinion or the presence of tangible material can be read into these sections, where the intent was to give a finality to assessment by reducing the time limit from 6 years to 3 years. Again, I think the misuse or abuse of these provisions will lead courts to provide some inbuilt checks into the section, so that the assessing officer cannot, on his whims and fancies and on caprices, seek to reopen concluded assessments. So here basically, I think we will wait for the courts to opine, because the 3-year period does not really have any fetters. Whether the concept of change of opinion will or will not apply. Now, somebody raised the question that if 13, 14, 14, 15 can be reopened pursuant to the Supreme Court judgment, and the Supreme Court says these are to be treated as notices under 148A, then you have actually lost the defenses that were earlier available of saying this is based on change of opinion, there is no tangible material. All those defenses under the old law have been lost. And the fact that, there was no failure to disclose fully and truly all material facts, those I thought were substantive amendments and therefore should have been used prospectively. But anyway, this is how now the law has developed, that these will also be governed by the amended section 148A. So it may not be possible to read those fetters, those inbuilt checks, and those jurisdictional conditions in the amended provisions of section 148A, where the reopening is done within a period of 3 years from the end of the relevant assessment year. So far as the extended 10-year limit is concerned, which says information which suggests, I think it must be tangible information leading to a reasonable belief that income has escaped assessment. Again, cannot be ipsy-dixy, cannot be based on, a wishy-washy conclusion or application of mind by the assessing officer that income has escaped assessment. So
Right.
I think, come again.
No, so Ajay ji, the limited point around the change of scope, there's an interesting question, is also on the process of the approval, which emanates from section 151, for, where the matters are opened beyond 3 years, but the approval is only from the commissioner and not the chief commissioner, which
Right.
is the requirement under the new law.
Right.
And, when the Supreme Court says that all the defenses are open, is this also an open defense that can be considered?
I would think so. I would think so. That
Right.
this can also be taken. I think one has to come all guns blazing, not leave out any defense. One doesn't know, which particular attack will strike the target.
Right. Ajay ji, beyond Supreme Court judgment, the new scheme of section 147, there are certain issues, and you pointed out already to one important point is the risk assessment framework.
Right.
And nobody is aware about what is the risk assessment framework. So any guidance on how this should be evaluated, and any legal defense can be taken. And I, at the cost of sounding a bit unpopular, I must also confess that the feedback I have from friends is that most of the times the information raised is very, very specific, and does raise a specific transaction as well. There could be some aberrations, but the risk assessment framework or the IT system does provide a pointed sort of direction as well. So some thoughts around this also will be useful.
See, today, Ahmed, according to me, the department is swamped with mass of information. In fact, there is information coming from so many sources. Now, the question is, how do you mine this information in an intelligible manner? You have received information that I have done a particular transaction. Now, that transaction may be duly reflected in my books of accounts. Just because you got this information that I have done a transaction does not lead to the conclusion that that income is unrecorded or that transaction is unrecorded. That transaction suggests escapement of income. So basically, I think the important point is that when you get this information, as an assessing officer, you are required to conduct an inquiry. I'll give you an instance which I've just concluded in the High Court yesterday. A partnership firm got converted into a company way back sometime in 2012. Now, there was the pan of the partnership that was kept alive for specific business reasons, but I'll not go into that. Now, the assessing officer of the partnership saw that on this pan, there is interest of some 26 odd thousand that was earned from an FDR, which was given as a guarantee to one of the statutory corporations. So he says, basis this, you have not filed a return of this partnership firm. The partnership firm was carrying on exports, which are now being carried on by the limited company. The partnership firm approached the customs department as to what are the kind of exports that were made. Some 300 odd crores of exports were made. The customs department, we don't know, the evidence never came on record, said that 300 odd crores of exports have been made by this. Now they responded in the firm, we don't know. So the name of the firm and the company was same except for the use of the word limited. So the custom department responded that 300 crores of exports have been made, which was added to my income. Now, despite my pointing out that the partnership gets converted into a company, despite my pointing out all entries are recorded in the books of accounts, the company has been assessed under scrutiny assessment for the relevant year. Despite that, all this was discarded and an addition made for 300 odd crores, the gross value of the sales. Now, we were at pains before the High Court to say that look at our books of accounts, they are all available. The entire thing is recorded in the books of accounts. So the point that I'm making when you say that there is specific information available, yes, there may be specific information, but somebody has to apply mind. Somebody has to carry out that inquiry. And the department, from what one has seen, some notices say that under 148AA, it says conduct any inquiry if required. Now, the department says it is our judgment whether any further inquiry is required or not required. So you may have a transaction that comes to his notice. Unless he carries out that inquiry, whether it is recorded in my books of accounts or not recorded, that cannot be the basis. You have, let us say, you have information that somebody has subscribed to the share capital of my company. Now, merely on that basis, can you reach a conclusion that this suggests undisclosed income or this suggests income that has escaped assessment? And you dispense with the inquiry saying inquiry is not required. That person is a named lender or that person is in the business of furnishing accommodation entries. So clearly, there are challenges that are happening. And I would think that the department needs to, apply mind at that stage to filter out cases where reassessment is not required, not to indulge in frivolous initiation of proceeding. That was the intent. The intent was to give finality to assessments and not lightly disturb the finality of assessment by initiating reassessment proceedings. I think there is a duty cast on the department under this amended provision, which unfortunately, given the fact that notices have been issued left, right, and center, and there you have huge volume of notices that have been issued towards 31st March. So whether that process can be done, and as was said in this Gazetted Officers Association's letter, I think it is humanly impossible for them to make available this information in 30 days with respect to all the cases that are pending. That for the assessees, the assessees can individually reply within 2 weeks, and for them to pass an order thereafter within the extended time. So they have to get their house in order. They have to put their act together. This will then lead to another, substantial round of litigation at the cost of the taxpayer, and it serves no purpose.
Right. Ajay ji, there has been a reference in the Supreme Court order around consensus among the councils of the taxpayers,
Right.
and whether it did happen as well. And there are contrary thoughts. Any perspective around that, and can that be the basis in the review when the review sort of comes up? Any observations, Ajay ji? Because this is one
No,
sort of.
I don't think the judgment is solely based on consensus. I think that's the understanding of the bench when the bench has passed the order. That is just mentioned in the passing.
Right.
You see, if it's a consent order, especially you have a settlement between parties and there's a consent order which is made a decree of the court, in that situation, neither party can walk out of that consent. But here they have referred to this question that there was broad consensus. If I may read, the relevant part. There is a broad consensus on the aforesaid aspects among the learned ASG. The aspects that have been dealt in the earlier part. So that is not the fulcrum of the decision of the court.
Right. Ajay ji, there have been several questions, and I guess many notices also pertain to the sale of a property. There are 2-3 sort of set of questions. One is, 50 lakh limit, is this applicable qua a single year or or can it be aggregated over a period of years? Once the asset is replaced with a bank balance after sale, is that an asset? Should you look at a gross consideration of the value of the gain? Some general observations around the interpretation around this. Ajay, this is 12:38. Perhaps with your permission, we could continue up to 12:45 and then end the session.
Sure.
Yeah.
Sure. No, so basically this amendment that is there in 149(1) capital A, that when I read this has come in by the Finance Act 22. Notwithstanding anything contained in subsection 1, where the income chargeable to tax represented in form of an asset or expenditure in relation to an event or occasion has escaped assessment, and the investment in such asset or expenditure in relation to such event or occasion has been made or incurred in more than one previous years, relevant to the assessment year within the period referred to in clause B, a notice shall be issued for every such assessment year for assessment, reassessment, or recomputation as the case may be. So I think then it may be the limit of 50 lakhs in the aggregate, because it talks of the amount which has escaped assessment is likely to amount to 50 lakhs rupees or more.
Right.
But like you saying that this is replaced by bank balance. So is this a sale recorded in books of accounts, or this is outside the books?
Yeah. So again, 2 scenarios in one where it could be an individual, and what is books of account if it is a non-business scenario.
No, but if it is reported for tax purposes.
So presumably it is not reported for tax purpose, which is why the reassessment notice is there. I mean, in fairness, department has a right to look at such things.
Yeah, sure.
There is no tax paid.
Right.
But right, Sachin, any other questions?
Not from my side at the moment.
As I told you, you have information from several sources. You register a property or you register a sale. The registrar of assurances makes available that information to the tax department. You have a substantial credit in your bank account, or you have cash deposited in your bank account. The bank will make available the information. So information is coming from several sources. That information needs to be intelligibly mined for the department to move forward by issuing these reassessment notices. Otherwise, it will send the assessee on a leather hunt. It will be the assessee who will have to bear the brunt of initiation of proceedings and point out that there is no income that has escaped assessment. But as you rightly said, it is also leading to unearthing undisclosed income, and therefore the department is resorting to initiation of proceedings under 147.
Right. So Ajay ji, that perhaps brings us to the last point for the day, and we have the judgment, we have the law, and we have the order and the direction from the Supreme Court. According to you, what might be the better course of action for the department, particularly at this stage? Any suggestions you have to make this a smooth ride? I mean, one course is, of course, again, there's a litigation back to the court. But if the Supreme Court order is to be given effect in its spirit, any practical suggestions? This could be, like I said, your personal view, Ajay ji.
See, basically, once the Supreme Court has laid down the law, it's only a question of interpretation. So the department, according to me, cannot possibly give a declaration which is contrary to the Supreme Court. They can issue a circular, but I doubt very much that anybody would come in by issuing a circular saying that you need not initiate proceedings for 13, 14, 14, 15 or drop the proceedings that have been initiated. I doubt it very much that somebody within the system will kind of issue such a clarification. That will be contrary to what the Supreme Court has said. Of course, this must then be debated at the highest level in the government if they have to come out with such a circular. That will be like a beneficial circular which may be binding, and it may or may not overstep what has been decided by the Supreme Court. One view will be that the Supreme Court does not save the assessments initiated for 13, 14, 14, 15, which are otherwise barred by limitation. But as I said, the other view is equally possible. So the question will be, can somebody stick their neck out and say that we are coming out with this clarification? Highly doubtful, according to my understanding. So therefore, willy-nilly, whether we like it or not, I don't think there can be any administrative clarity around this issue. The department will also seek to lobby this back into the court, that let the court decide on how we need to proceed and implement these directions of the Supreme Court. At least I don't see a resolution where the taxpayer and the tax department can sit together and try and reach a consensus on how to implement these directions. Giving up 13, 14, 14, 15 and other years will be really a concession on the side of the department. So whether somebody has the authority, the jurisdiction to make such a concession is an open question. The constitutional courts can. They will only seek to interpret the direction of the Supreme Court read with the law.
Right. Right. Thank you, Ajay ji. And
I'm for another round of litigation. I think that's all that I can say.